Hey folks, my name is Josh Keck, and I wanted to make a quick video going over the data center taxation system scheme that the West Virginia legislature came up with in House Bill 2014. So what I'm going to do is I'm going to try to explain this scheme and then address the legal issues behind it and why this scheme is unconstitutional for two reasons. Okay, so disclaimer, I'm not an expert on data centers by any means, but I am trying to research them and understand them. I do consider myself an expert on levies and property taxes, and I will take that to the bank. And then I am also running for state senate. This has nothing to do with me campaigning for office. It's just me trying to explain things in the way that I know how to explain them. So if you're interested in campaigning stuff, that's not here nor there. All right, so let's start with this. The way property taxes work in the state of West Virginia, you've got a few different levying bodies. You got county commissions, you got boards of education, and you've got municipalities, so counties, schools, and cities, who can levy taxes. The Constitution, Article 10, Section 1 of the West Virginia Constitution, has limits on how much those property taxes can be. And that was the result of the 1932 Tax Limitation Amendment, where the voters back in the Great Depression were really pissed off at the local governments about how much they were raising in property taxes, and they said enough is enough. And 90% of the voters approved a constitutional amendment to limit their authority to do that. So that is still to this day the most popular constitutional amendment the state of West Virginia has ever passed. Fun fact trivia for you. But what it says, let's go ahead and let me share my screen here. I'm going to bounce around a bit. So Article 10, Section 1, this is what I'm talking about. This is the Property Tax Limitation Amendment. I'm going to come back to this. It says a bunch of stuff, right? There's a lot of stuff in here. What's important to me is that last sentence, but let me back up before we get to that. All right. So what does House Bill 2014 do in this regard? So this is the final enrolled version that I'm looking at here, okay? And House Bill 2014 does lots of different things. You can see the summary here. It establishes high impact data centers. It defines what qualifies, who certifies them, all that stuff. But what's of importance to me in this video is the way it treats the certified data centers and their taxation, and their property taxes. All right, so first section here goes into definitions. The most important definition to understand is the difference between base assessed value and the current assessed value. So the purpose of what they're trying to do here is they're trying to say, I need to know what the value of the property was prior to the construction of this high impact data center, and what is the value after the construction of this high impact data center. And I want to know that so I know the difference between the two. How much more tax did this data center bring in, right? So the base assessed value is pre-construction, and the current assessed value is post-construction. And the difference between those two is what you'd call the incremental value, right? And the tax increment is what you'd call the tax revenue raised based on that incremental value. Okay, so those are some of the definitions for you. All right, here it goes into special rules for tax distribution of high impact data centers. All right, so it gives the state auditor some authority to do a lengthy calculation and then distribute money. All right, so that calculation is 5 parts. These are the 5 parts. Part A here is that we're going to calculate the current property value, we're going to calculate the tax rate based on the current property value post construction. All right, we're not going to do anything with that just yet. We're just going to say, what is the total tax based on the current value of this high impact data center? Paragraph B is going to say, well, then I need to know what was its pre-construction value, the base assessed value. I want to know what it was before, what it is now, and what it was before. And then paragraph C is saying, well, what was the tax just for general obligation bond debt service? That's a different levy rate from our regular taxes. So these first two are very specifically about the regular levy rates, the regular ones. All right. So this was actually the aggregate of all of them, but again, we're not doing anything with this. So what are the regular levy rates for the base rate? what are the applicable bond levy rates, what are the applicable excess levy rates, and then what is the rate, what is the regular levy rate on the incremental value piece. So we're trying to figure out how much is the regular levy increased and how much are the excess levy and bond levies now. But there's a distinction here between the bond levies and the excess levies, which is really important. I'll come back to it, but just keep in mind there is a really important distinction with this. All right, so we're calculating all these numbers to figure out, how much new tax are we talking about? And then we go on to say the state auditor is going to distribute these funds. And it's really weird the way they've written this, but this is where they say how these monies are going to be distributed. So again, paragraph A here, we're not doing anything with. It starts with paragraph B. We're not going to do anything with paragraph A. That's the total tax that we're talking about. We're not doing anything with the total tax. That's just information only. The first tax we're going to do something with is the regular tax on the pre-construction base assessed value. What are we doing with it? We are going to give that to the levying body that it's entitled to. All right. So if the data center had never been built, that money was going to them anyway and still is. Okay. That money's not getting distributed. The pre-construction money is not getting divvied out to anywhere else. It's going exactly where it always went. That's what this says. All right. The bonds, the money raised for general obligation bond debt service, that money is going to go to these levying bodies as well, right? So none of that's going to get into any kind of weird distribution mechanics. That's going to the levying bodies as well, as are the excess levies. All right. So paragraph B, C, and D is saying the pre-construction tax revenues going to the counties and boards of education and cities. The bond levy money is going to them, and the excess levy money is going to them. No issues there. Where things get wonky is this one right here. What about the incremental money from paragraph E up here? What about the incremental money, the new tax revenues? What about the new tax revenues based on the regular levy rates? What about the new stuff? Well, the new stuff is going to get distributed in this strange way where it's going to be divvied out. So the county is going to keep 30% of that for the county commission and the school boards and the cities. They'll get 30%, not 100% like normal. They'll get 30%. The other 70%, 50% is going into a state fund called the Personal Income Tax Reduction Fund. Another 5 and 5% are going into two other funds that the state created. And then 10% is going to go to every other county based on a per capita basis. Okay. There's two issues. The first issue is you can't. All right. So the first issue is the way that this property tax works. What you're seeing here is 60%. The 50% to the personal income tax fund and the 5% going to each of these two funds, that 60% of the incremental money raised because of the construction of the high impact data center is now going to the state. 60% of the money is going to the state. Okay? Back to our Constitution, right here, the Tax Limitation Amendment from 1932 makes it very clear after the year 1933, the rate of the state tax upon property shall not exceed 1 cent upon the $100 valuation. So what does that mean? It's easier if you see it see it here. This is the tax website for West Virginia. See this one right here? That's the state tax rate. And rates are given based on in terms of $100 valuation. The state is only allowed 1 cent per $100. Okay? The rest of the money, the tax limitation amendment caps it at $2 per $100. And if you need to know where that is, it's in here. It's in here somewhere. Right here, $2. All right. $2 on class 3 and 4 property, $2 per $100 evaluation. That is the limit that property taxes can be. And that is then a big pizza pie that gets sliced and diced amongst the state, the county, the schools, and the cities, if applicable. And the state only gets a very tiny slice of the pie, 0.5% of class 3 and 4 or class 4 property. 1 cent per $100. All right. And why is that? It's because it's literally right here in the Constitution. So what are they doing with House Bill 2014? They're taking 60% of the incremental tax funding, which is the same as saying this tax rate is now 60 cents per $100. If I'm doing my math right. Actually, it might be $1.20. Actually, I think it's $1.20. Essentially, what's happening, though, is they're going way, way, way past the constitutional limit by taking this property tax money and putting it into these state funds. The Constitution is just facially being violated with this scheme, right? This scheme that takes 60% of that revenue raised, of the incremental revenue. And it doesn't matter that it's incremental revenue or base revenue. It doesn't matter like how they distinguish the fact that, you know, without this, there would be no data center. That's not how it works. It doesn't distinguish in any way. The Constitution literally is just how it says. The state tax upon property shall not exceed 1 cent upon the $100 valuation. And we're at well above that, whether it's 60 cents or $1.20, I'm not exactly sure, but the property tax goes well beyond this. Okay, I guess it technically would be $1.20 if it's a municipality. It wouldn't be a municipality, so it would be 60% of the total here is basically what it would be. 60% of the total there. All right. So point number 1. Article 10, Section 1 of the Constitution is facially violated by House Bill 2014 due to this reconfiguration of where the money is going into these state funds and to these county funds, for that matter, as well. The all-county fund, this 10%. Nothing in the Constitution grants the legislature the power to take a local property tax, and reallocate it to all counties. There's nothing that grants them the authority to do that. Nothing. The other issue, beyond just this being unconstitutional on its face, the other issue is scrolling back up to. It's an important distinction here. It's really hard to see this, but there's an important distinction between the way they do the tax rates for bond debt service and tax rates for excess levies. So both of these things are things that voters have to approve. Excess levies are money raised above and beyond the constitutional maximum, right? So when I talk about the maximum, I'm talking about these things. Excess levies is money above and beyond those tax rates, and those have to be approved by voters, and they can be approved at the ballot box, right? And when you do that, you enter into a contract with the voter. You say, voter, I would like to raise money for XYZ purpose. And the voter says yes or no. And if a majority or a supermajority of them approve that, you now have a contract. That money, the additional money raised, must be spent on the XYZ project you said it was going to be spent on. Okay? Now, the way the excess levies work, that's not a problem, because we're saying we're multiplying the current assessed value of the property by the current excess levy tax rates. That's good. That means, you know, if the school board wants to have an excess levy, then, you know, and it gets approved by the county, and we're going to use that money for salary supplements and playground equipment, all good. The data center is going to get taxed just like every other business is going to get taxed based on its current assessed value, and the school board is going to get all of that money. It's not going to be divvied out to any other entity because, again, down here, that's what we're saying is that share will go to the levying bodies who are entitled to that distribution because they have that excess levy. All right. So the voter approved excess levy is going right where it should be. That's great. The distinction, it's really subtle, but the distinction right here between these is that the excess levy is on the current assessed value. But when you talk about it being for bonds, so let's say, you know, instead of salary supplements and playgrounds, now let's say the school board wants to build a new school, and they ask the voters to approve a school bond in order to go into debt in order to pay for the school. So they go into debt, and then over 20, 30 years, the voters allow themselves to be taxed a higher rate in order to pay off that school bond's principal and interest costs. All right. The problem here is this one is not based on the current assessed value of the property, here the amount of tax revenue is only going to be based on the based assessed value or the pre-construction costs of the data center. Only the pre-construction costs of the data center, like the pre-construction value, only the tax that's raised, if you approve this, the tax that's raised is going to be applied to the current value because that's how taxation works. It's applied to the current value, but only the pre-construction base value, a much smaller number, only that amount is going to be distributed to the levying bodies for their general obligation bonds. So that violates this contract between the levying body and the voters. The levying body says, we want to build this school and we need to levy property taxes in order to do so. Would you like to have that happen? Yes or no? The voter says, yes, I agree. You can tax all the property. You can tax me a higher rate for my property. And that money must be spent for debt service. Okay. But what this is saying is we're taxing this post-construction value. We're taxing this, the current value of the data center, but of that money that gets raised, only the base pre-construction value can go to that bond service. So we're collecting a bunch more money, like a lot more money because that data center got built, but it's not going to bond service. It's not going to pay off that debt, which is what we voted for. And so that violates this contract with the voters. And so again, that's reason number 2 why House Bill 2014's financing system is unlawful, unconstitutional. That one's not facially unconstitutional. That's more of a common law issue. If you go through and look at Supreme Court decisions on bonds and excess levies, they're very clear. When you place something on a ballot and the voters approve that thing on the ballot, that becomes a contract and the money raised must be spent on that purpose. You can't take this additional money, the increment money, that's being taxed at that bond tax rate. You can't take that extra money and then go ahead and put it into a state fund for that's completely unrelated to paying off that bond. Can't do it. So anyway, that's what I wanted to make this video about. There's one more thing that I'll throw in here, which is my buddy Daniel Linville has this calculator that he's put on this website. And I'll be honest with you, it's a decent calculator. I tested it. I worked through it. It's confusing at first, and it's not the full picture because it doesn't include municipalities and it doesn't include bonds, but it's not the worst calculator in the world. So you could go to his website and check it out. Again, it's meant to sell you on the idea that these data centers are good because you're going to get all this money. But more importantly, it exposes the unconstitutional scheme of this. So I put in Mason County as the host county where the data center is getting built. I put in Cabell County because that's where I live. And then I put in 2 gigawatts as the project size because that's what the phase 1 of the Monarch Compute Campus in Mason County is supposed to be, 2 gigawatts. It's an $80 billion investment. That's about right. I think it'll cost more like $100 billion because the NVIDIA Vera Rubin GPUs will be more expensive by the time they're ready to construct. It's the latest generation. So it'll probably be a little bit more, but we'll see. All right. So then you've got these 3 tabs that all have different information. And I think starting out, it makes sense to start out with all of West Virginia. So all of West Virginia, if you scroll down, the entire regular tax levy revenue on this $80 billion project will be $186 million. $186 million. It's a lot of money. That's the regular tax levy revenue. So if you go back to House Bill 2014, like that step A is figuring out not that step A. This step A, what is the assessed value of the property multiplied by the total of all applicable levy rates? Actually, that's not even step A because that's just regular. That's just regular levy rates. Step A is technically this number, 326 million. That's on the host county tab. The host county doesn't get all that 326 million, but that 326 is a combination of the regular levies and the excess levies. This number here is only the regular levies, the 186. And so then it shows you, sorry, I guess I'm not showing that properly, but then it shows you where that gets distributed. So that 50% to the state fund for income tax, 93 million. 10% to all the other counties split by population, 18 million. And you can see where those numbers are moving around. Again, that's all unconstitutional. The state can't just take 60% of your property taxes. They're limited to 1 cent per $100 of valuation for that state tax. This is facially invalid. And then under my county, so my county as Cabell will benefit from this 18 million. And how much of the 18 million? 992,000 based on this calculation, based on the census. Based on property tax or property record or population records. Sorry. All right. And then of the host county gets 55 million in regular levy money, the regular rates. But then they also get those excess levies that we talked about, right? So they'll get these 32 million to schools and 23 to county commission. Again, it doesn't mention municipalities, so that's a weakness in this calculator. But then because Mason County, as the host county, has excess levies for their school, there's another 126 million because the school gets all of the current value of the data center, not just the base value, but all of the current value post-construction. So it is a considerable amount of money, plus the fact that schools are just raising ridiculous amounts of money with these excess levies. And then for EMS, the same deal. It's a large amount of money there as well because, again, they're able to take advantage of the entire post-construction amount, and none of that gets distributed outside the county. So add all of those up and you see these two amounts, and this 326 is the total between regular and excess levies, of which, still a good portion is going to the county because of those excess levies. Bonds are not mentioned in this calculator, but bonds would screw the whole formula up because the way they did it. This really leaves open a question of, like, what do you do with the incremental money that was based on the bond rate? What do you do with that money? Does it just go into that slush fund to be distributed, or does it have a home? I'm a little confused on that, but it's a subtle distinction here. When you look at the law, it's a very subtle distinction, but it's very important. The base assessed value or the current assessed value. It's a very important distinction because that's a large amount of money that's not being used for the reason by which voters approved it to be used with these bonds. So, okay, I think I spent enough time on this. If you guys are interested in this stuff and would like other explanatory videos on these data centers that are being constructed, I could do this for hours. No, I really could. I could do this for hours. I just wanted to focus mostly on the taxation effect. So what needs to happen? Someone who lives in one of these counties that has a certified high impact data center would probably have standing and would need to file a lawsuit in circuit court. And that lawsuit would look like you'd probably ask for two forms of relief. You'd most likely sue the state auditor. You might also add the state attorney general as a party to the suit, but really the state auditor would be the one that would be the plaintiff. Sorry, not plaintiff, but the respondent. You'd be the plaintiff, the respondent. And the state attorney general would then argue the case. They'd use their lawyers to argue the case. There's a whole procedure about how that has to be done, the time frames. You have to give them 60 days notice and all this stuff, but and you have to give them a 30-day written notice before you even file the suit, and then they have 60 days to respond. So it's a slow process, years long potentially. But if you live in one of these counties, you probably have more standing than, say, I would in Cabell County, where there is no high impact data center. But you would ask for two forms of relief. You would ask for a preliminary injunction against the state auditor. And that injunction would basically say to the state auditor, if the judge approves it, you cannot distribute any of that money to the other counties or to this income tax fund or to these economic development funds or even to the 30% to the county. All of that money that has been raised would need to be frozen in time until this case is complete. That would make it so that as this case, hammers out for several years, they couldn't start distributing the money before it's settled. So a preliminary injunction would prevent a permanent injury from taking place. Then the second form of relief would be a declaratory judgment, which is saying to the judge, read the Constitution, see that it facially says right there that state tax can only be 1 cent per $100 of value, and see that they're actually trying to do 60% of all these property taxes, so it far exceeds that. So declare that House Bill 2014's taxation scheme is unconstitutional. The declaratory judgment would be a judgment from the judge that it is unconstitutional. So part one of the unconstitutional would be the way that the taxes are distributed to the state funds, and then part two would be the violation of the contract between the voters who approve a bond and the money raised for that bond being spent on ulterior purposes that the bond was not part of. So two forms of relief: preliminary injunction, declaratory judgment. Maybe also a writ of mandamus, but I'm not sure what you'd need it for, but probably just those two forms of relief. You'd file that in circuit court in the county in which you live. You may have to file in Kanawha County for this. I'm not sure. There are some times where you can sue the state and you can sue in your local county. I want to say you could file this in your local county. The rules on that changed not too long ago. So you might be better off filing in Kanawha County anyway, because it's a complicated thing. You want a judge who's going to take the time to look at it. And who, but anyway, I have spent long enough on this. If you're interested in this kind of stuff, let me know. I'll make more videos. I wanted to get this one out because this is really interesting to me. So thanks a lot. Appreciate y'all.